Hey everyone, and welcome. Have you ever found yourself wondering what actually happens when a business here in the Philippines just hits a financial wall? From the outside, it can look like total chaos, but believe it or not, there's a whole rulebook for this exact situation. So today, that's what we're going to do. We're going to break that rulebook down step by step.
So just imagine this for a second. A local business can't pay its suppliers, it can't cover the rent, and it can't make payroll. Is it just game over? Well, not necessarily. The law actually provides a very specific fork in the road, and the path they choose makes all the difference in the world. So here's our roadmap for today. We'll start with the law itself. What is FRIA? Then we'll get into who it actually covers. After that, we'll explore those two critical paths, the rescue mission they call rehabilitation versus the final chapter, liquidation. We'll also look at a special pause button that's only for individuals, and then we'll wrap it all up by talking about why this law is so important for all of us.
All right, let's dive right in. First things first, what exactly is this law we keep talking about?
Okay, so its full official name is Republic Act number 10142. But, that's a mouthful, so pretty much everyone just calls it FRIA for short. It was passed back in 2010, and it's the legal framework that snaps into place whenever a person or a business gets into serious financial trouble.
And here's the real idea behind it all. FRIA isn't about punishment. It's not about pointing fingers. The whole point is to create a fair and orderly process where the person who owes money and the people who are owed money can come together and find a realistic solution. It's all about resolution, not ruin.
So who exactly gets to use this framework? Let's take a look at the key players in this whole drama.
First, we got to get our heads around what insolvent actually means under this law, because there are two very distinct types. The first is being illiquid. This is where you might have assets, like buildings or equipment, but you just don't have enough cash on hand to pay the bills as they come due. Then there's what we usually think of as insolvency, where your total debts are simply bigger than everything you own. The big takeaway here, FRIA can apply even if you have assets. A temporary cash flow crisis can be enough to kickstart the whole process.
The law is pretty broad about who it covers. A debtor can be a sole proprietorship, which is the simplest kind of business. It can be a partnership or a full-blown corporation. And yeah, it absolutely applies to individual people too when they find themselves in over their heads.
But, and this is a big but, there are four major exceptions. A really easy way to remember them is with the acronym BIPG. That's banks, insurance companies, pre-need companies, and government agencies. These guys are considered so crucial to public trust that they operate under their own, much stricter set of laws when they run into financial trouble.
Okay, so now we're at that fork in the road I mentioned. Let's explore the first path you can take, rehabilitation. You can really think of this as the rescue mission.
The goal here is pretty much right there in the name, to restore the business. This is the path you take when everyone agrees that the company is actually more valuable alive than it would be if it was just sold off for parts. The whole point is to get it back on its feet, solvent and operating successfully again. Now, FRIA gives you three different ways to try and pull off this rescue. The first is court-supervised, where a judge oversees the whole thing from start to finish. The second is pre-negotiated, where the debtor and creditors work out a rescue plan first and then take it to the court for a stamp of approval. And the third way is completely out of court, through a more informal agreement as long as enough creditors are on board.
And speaking of getting creditors on board, just look at the high bar for that out-of-court option. You need creditors holding at least 67% of the secured debt, 75% of the unsecured debt, and a whopping 85% of the total debt to all agree. These thresholds are so high to make absolutely sure that any informal rescue plan has overwhelming support from the people who are owed money.
So what happens if a rescue just isn't in the cards? Well, that brings us to the second path at that fork in the road, liquidation. This is the final chapter.
Liquidation is pretty much the end of the line. It's the formal, legal process of selling off everything the debtor owns, turning it all into cash, and then distributing that cash to the creditors in an orderly and fair way. This is what happens when trying to save the business just isn't a realistic option anymore.
And this slide really nails the fundamental difference, doesn't it? The goal of rehabilitation is to save the business. The goal of liquidation is to close the business. You're starting from the same point of financial distress, but you end up at two completely different destinations.
So how does a liquidation get started? Well, it can happen in two ways. It can be voluntary, meaning the debtor themselves raises their hand and files the petition, or it can be involuntary.
That's when 3 or more creditors who are owed a combined total of over $1,000,000 or at least 25% of the company's capital basically force the issue.
All right, let's shift gears a bit and talk about a special tool that's only available to individual people. It's not quite rehabilitation and it's not quite liquidation. It's something in between, a unique kind of pause button.
This is called a suspension of payments. It's specifically for an individual who is temporarily illiquid. Remember, that means they have enough assets to cover their debts. They just can't make the payments right now. This process lets them hit pause to get their cash flow sorted out. But, and let's be super clear on this does not forgive or reduce the debt one bit. It just pushes back the due dates. So when a court grants this suspension, it puts a stop to most creditors filing new lawsuits to collect their money. But there are some huge exceptions. A secured creditor, like a bank with a car loan, can still go after the car. And certain critical claims, like an employee's salary or recent urgent family expenses, can't be stopped either.
So okay, we've gone through all these different processes and rules. Let's take a step back and ask the big question. Why does any of this even matter?
Well, when you look at the big picture, a law like FRIA is absolutely crucial for a healthy economy. It gives a second chance to businesses that are struggling but still viable, and in doing so, it helps save jobs. At the same time, it protects creditors from a chaotic free-for-all by creating an orderly, fair process. For everybody involved, it replaces total uncertainty with a clear, predictable set of rules for navigating a crisis.
And that leaves us with one final big question to think about. For an economy as a whole, which path is actually better? The rescue mission of rehabilitation that tries to save businesses and jobs? Or the finality of liquidation, which clears out failing businesses to make way for new growth? Honestly, there is no easy answer. Definitely something to chew on. Thanks so much for joining me today.